Hey, Kenneth. Kenneth, can you hear me? Okay. Jermaine, can you say something? Can you say something, Jermaine?
Testing 1 2 1 2 testing 1 2.
Did you hear Jermaine say something, Kenneth?
I can hear you.
Thank you, Kay.
You're welcome.
Kenneth, hold on.
Yeah. Ask him to show the room, please. Kay, can you hear me, Kay? You guys can hear me.
Yes, I can.
Kay, can you hear me?
Yes, yes, I can. I can hear
Any one
you.
of the interpreters, can you hear me? Yes, the interpreters can hear me too. So yeah.
Yep. We can hear you. We just can't.
Liz, were you able to hear me in the Zoom? Interpreter Liz.
Yes, I can hear you.
I can hear you. Jermaine, can you hear me? Liz, can you tell him that I am speaking? Okay, thank you.
I'm able to hear you, yes. Jermaine, are you able to hear us? I don't think you can hear us. I think it's only us who able to hear him.
Kenneth, can you show the room, please?
don't know what to say. It doesn't help me any. I should have had one that oh, I don't have it.
Kenneth. Kenneth, can you show us the chamber, please? Thank you, Kenneth.
Mic check four, mic check four. Testing 1 2 1 2. 1 2 1 2. 1 2 3. 1 2 1 2. 1 2 1 2. 1 2 1 2. 1 2 3. 1 2 1 2. 1 2. 1 2 3. 1 2 1 2. 1 2 1 2. 1 2 3. 1 2 1 2. 1 2 1 2. 1 2 1 2. 1 2 3. 1 2. 1 2. Kendall. Larry, call Jermaine. I need him on the video. Larry. Larry. Jermaine, are you there? Jermaine.
We can hear you on the Zoom if that's what you're checking for.
That's what I am. Councilmember, can you do
Okay.
me a favor? Can
Yeah.
you give me a 10 count?
Yep, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Kenneth, did you get her? Thank you, Councilmember.
You're welcome.
I'm calling to order this meeting. This is a regular meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. This is a regular meeting of the Committee of the Whole. It will be followed by an additional meeting, a legislative meeting of the full council. Today is Tuesday, October 15th, 2024. The time is 12:15 in the afternoon. And we are in room 412 of the Johnny Wilson Building. We moved here from the council chambers because of some issues with power that occurred earlier this morning to the building. This hearing, I believe, is being broadcast on Council Channel 13 and is available on the council's website, www.dccouncil.gov. We have a couple of resolutions for consideration in the Committee of the Whole, and then something like 10 or 11 measures that have been reported out of other committees. We'll begin first with determining whether we have a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson,
Present.
Councilmember Allen,
Here.
Councilmember Bonds,
Here.
Councilmember Fruman,
Present.
Councilmember Gray, Councilmember Henderson,
Present.
Councilmember Lewis George, Councilmember Lewis George, Councilmember McDuffie,
Here.
Councilmember Nadeau,
Here.
Councilmember Parker,
Here.
Councilmember Pinto,
Present.
Councilmember Robert White,
Present.
Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. I see that Councilmember Lewis George is on the Zoom, but she did not answer when you called the roll. So we have the Secretary's report of committee filings. I'm going to recognize the Chair Pro Tem, Mr. McDuffie.
Thank you, Chairman. I move to waive the reading of the Secretary's report.
On a motion to waive the reading of the report, is there discussion? On the motion to waive the reading, all those in favor say aye. Opposed? The ayes have it unanimously. We have the Secretary's log of introductions and referrals. Again, I'll recognize the Chair Pro Tem, Mr. McDuffie.
And I will move to waive the reading of the Secretary's log of introductions and referrals.
There's been a motion to waive the reading. Is there discussion? On the motion to waive the reading, all those in favor say aye. Opposed? The ayes have it unanimously. For consideration in the Committee of the Whole, first we have a resolution of staff appointments, Committee of the Whole Staff Appointment Resolution of 2024. I attended a markup of the Housing Committee earlier this week and was reminded indirectly that our rules require that appointments to committee staff have to be approved by the committee. We have this year hired Aaliyah McNeely as the Legislative Policy Advisor working on education issues. She lives in Ward 5, and most recently we hired Anna Kozik, who's also a Legislative Policy Advisor, again working on education issues. The resolution was circulated on Friday, and I move the resolution, which is the Committee of the Whole approving the appointments. Is there discussion? On the resolution, all those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously, and note that Councilmember Lewis George participated. I'm going to move PR 25-957, which is a resolution PR 25-957 entitled "The Board of Trustees of the University of the District of Columbia Esther Barazone Confirmation Resolution of 2024. The purpose is to confirm the mayor's nomination of Dr. Esther Barazone for reappointment as a member of the University of the District of Columbia Board of Trustees for a term to end May 15th, 2029. Dr. Barazone holds a Bachelor of Arts degree in Philosophy and History from New College in Sarasota, Florida, and she has a Master's of Arts and doctorate degrees from Columbia University. For 24 years, Dr. Barazone served as president of Chatham University, retiring from that position in July 2016. Dr. Barazone has received numerous awards, served on multiple boards, and participated in an extensive number of organizations. Of particular relevance is her involvement with Middle States Association of Schools and Colleges, where she has served as an accreditation reviewer and also was an accreditation team chair in 1999 and 2014. As Middle States is the accreditation body for UDC, the committee believes Dr. Barazone's knowledge of Middle States is a valuable resource to the university and will allow her to aid UDC in continuing to meet Middle States accreditation criteria. UDC is both a historically black college and university, or HBCU, and an urban land grant institution. Formed in 1975 from the merger of the District of Columbia Teachers College, the Washington Technical Institute, and the Federal City College, UDC serves as the district's only public university. UDC's mission is to provide an affordable post-secondary education to district residents and to, quote, prepare students for immediate entry into the workforce, the next level of education, specialized employment opportunities, or lifelong learning, unquote. In furtherance of this mission, a law school was added in 1996 and a community college in 2009. UDC is governed by a board of trustees comprised of 15 members. Of the 15, 11 are appointed by the mayor with the advice and consent of the council. 3 are alumni from either the university or one of its predecessor institutions, and 1 is a full-time student elected by the UDC student body. Each trustee, except for the student trustee, serves a 5-year term, and each non-student trustee may serve 2 consecutive full terms. Dr. Barazone is a Ward 3 resident and has served on the board since December 20th, 2016. Dr. Barazone is currently serving in a holdover capacity, which will expire November 11th, 2024. This resolution was introduced at the request of the mayor on September 16th, that is like a month ago. And the committee of the whole held a roundtable on October 7th, meaning a week ago. I will note that she's in a holdover position and she cannot continue serving after November 11th. So we appreciate that the mayor finally got the reappointment resolution to us. Dr. Barazone's previous experience and dedication to the board is impressive. Through her testimony as well as her responses to pre-roundtable questions, the committee believes that Dr. Barazone has demonstrated that she understands both the successes and challenges of UDC and that she is fully committed to ensuring that the university succeeds. There was no testimony or comments received in opposition to the nomination. If there's no objection, I'll move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? On the motion, which was to approve both the print and report with leave for staff, all those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. And I'll note that Councilmember Pinto and Louis George are participating virtually. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
And Madam Budget Director, because it's a confirmation, it doesn't have a fiscal impact statement, correct?
Correct.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. We will turn now to measures from other committees. And the first 6 measures were reported out of the Committee on Business and Economic Development, chaired by Councilmember McDuffie. The first is PR 25-802, Alcoholic Beverage and Cannabis Board, Terry Janine Quinn, Confirmation Resolution of 2024. Mr. McDuffie.
Thank you, Chairman. Proposed Resolution 25-802, the Alcoholic Beverage and Cannabis Board, Terry Janine Quinn, Confirmation Resolution of 2024 was introduced on May 10th, 2024 by Chairman Mendelson at the request of the mayor and referred to the Committee on Business and Economic Development on June 11th, 2024. The committee held a public roundtable on the proposed resolution on October 2nd, 2024. If approved, this resolution would confirm the appointment of Terry Janine Quinn as a member of the Alcoholic Beverage and Cannabis Board for a term to end May 7th, 2027. Ms. Quinn is a practicing attorney in the district. Currently, she practices compliance law with a specific focus on anti-corruption, anti-bribery, and money laundering issues. She spent a significant part of her legal career practicing energy law at White and Case LLP. Ms. Quinn is president of the Bloomingdale Civic Association, a position she has held for over 13 consecutive years. And as president of the Civic Association, she successfully represented Bloomingdale before several district agencies, including the Alcoholic Beverage and Cannabis Administration. Likewise, she has assisted many Bloomingdale residents and businesses on issues related to APCA. Ms. Quinn received a Bachelor of Arts in Journalism from Texas Southern University and her Juris Doctor from Howard University. She is a Ward 5 resident. With that, I move the resolution and ask that it be placed on the consent agenda for today's legislative meeting.
Are there questions for Mr. McDuffie? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, this is an appointment, so it doesn't have a fiscal impact statement.
Correct.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. Next, PR 25-806, District of Columbia Public Service Commission, Richard Beverly Confirmation Resolution of 2024. Mr. McDuffie.
Thank you, Chairman. Proposed Resolution 25-806, the District of Columbia Public Service Commission Richard Beverly Confirmation Resolution of 2024 was introduced on May 14th, 2024 by Chairman Mendelson at the request of the mayor and referred to the Committee on Business and Economic Development on June 11th, 2024. The committee held a public roundtable on the proposed resolution on September 24th, 2024. If approved, this proposed resolution will confirm the reappointment of Richard Beverly as a full-time member of the Public Service Commission for a term to end on June 30th, 2028. Mr. Beverly has had a long career in the realm of public utilities in the District of Columbia. He is an experienced District of Columbia government employee, having started working for the district in 1983. He has served on the District of Columbia's Public Service Commission since 2016 as a commissioner and worked before then for the commission since 1997 as general counsel. Mr. Beverly was also a political appointee under the Clinton administration with the Department of Labor as a member of their Administrative Review Board. Mr. Beverly received a Bachelor of Arts from Howard University and a Juris Doctor from American University. He is a Ward 1 resident. With that, I move the resolution be placed on the consent agenda for today's legislative meeting.
Thank you, Councilmember McDuffie. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, no fiscal impact statement is required because it's a confirmation.
Correct.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure is PR 25-811, 818, PR 25-818, Real Property Tax Appeals Commission Robert C. Cooper Confirmation Resolution of 2024. Councilmember McDuffie.
Thank you. The proposed resolution 25-818 was introduced on May 22nd, 2024 by Chairman Mendelson at the request of the mayor and referred to the Committee on Business and Economic Development on June 11th, 2024. The committee held a public roundtable on the proposed resolution on September 24th, 2024. If approved, this proposed resolution would confirm the appointment of Robert C. Cooper as Vice Chairman of the Real Property Tax Appeals Commission for a term to end on April 30th, 2027. Mr. Cooper started his career at a law firm handling real estate asset management and land use zoning issues. He then served in the District of Columbia government as Vice Chairman of the DC Housing Agency Board and as Chairman of RIPTEC's predecessor, the DC Board of Real Property Assessments and Appeals. He currently works for Cooper and Crickman, PLLC, a real estate law firm that he founded. Mr. Cooper received a Bachelor of Business Administration and Finance from Howard University and a law degree from George Washington University School of Law. He is a Ward 4 resident. As I noted during the committee's markup of this resolution, his appointment will fill a longstanding vacancy of vice chair, and I'm hopeful that the commission, now fully staffed, will be able to address the backlog of appeals and have it quickly resolved. With that, I move that the resolution be placed on the consent agenda for today's legislative meeting.
Thank you, Councilmember. Are there questions? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Because none is required.
Yes.
Thank you. Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. If there's no objection, the next three will be considered together. They are each appointments or nominations to the Washington Convention and Sports Authority Board of Directors. The first is PR 25-964, Washington Convention and Sports Authority Board of Directors, George T. Simpson, Confirmation Resolution of 2024. The second is PR 25-965, Washington Convention and Sports Authority Board of Directors, Marissa Flowers, Confirmation Resolution of 2024. And the third is PR 25-966, Washington Convention and Sports Authority Board of Directors, Monica Ray, Confirmation Resolution of 2024. Councilmember McDuffie.
Thank you, Chairman. All three of the aforementioned resolutions were introduced on September 17th, 2024 by Chairman Mendelson at the request of the mayor and referred to the Committee on Business and Economic Development on October 1st, 2024. The committee held a public roundtable on the three proposed resolutions on October 2nd, 2024. Proposed Resolution 25-964, the Washington Convention and Sports Authority Board of Directors, George T. Simpson Confirmation Resolution of 2024, if approved, would confirm the reappointment of George T. Simpson as a member of the Washington Convention and Sports Authority Board of Directors with expertise in business finance for a term to end on May 16, 2028. Mr. Simpson has spent the majority of his career with Spectrum Management, a company that he founded and serves as president for, that provides real estate development, construction, and maintenance services. Mr. Simpson is active in DC sports scene, both as team owner of DC Breeze, a professional ultimate Frisbee team, and as an advocate for youth sports with various organizations throughout the District of Columbia. Mr. Simpson received a Bachelor of Arts in Political Science from the University of the District of Columbia, and he is a Ward 4 resident. Proposed Resolution 25-965, the Washington Convention and Sports Authority Board of Directors, Marissa Flowers Confirmation Resolution of 2024, if approved, would confirm the appointment of Marissa Flowers as a member of the Washington Convention and Sports Authority Board of Directors with expertise in business finance for a term to end May 16th, 2027. Mrs. Flowers had a distinguished career in both public service and the private sector, focused on regional economic development. Mrs. Flowers served as Chief of Staff for my council office when I represented Ward 5. After her time with the council, she served as Vice President of Administration for RLJ Lodging, a real estate investment trust firm that owns over 100 hotels. She's also the founder and principal of Green Door Advisors, which is a CBE real estate advisory firm providing strategy and consulting services. Currently, though, Mrs. Flowers serves as the Chief Operating Officer and Executive Vice President of Strategy for the Greater Washington Partnership. Mrs. Flowers received a Bachelor of Arts from the University of California, Berkeley, and a Master's in City Planning from the Massachusetts Institute of Technology. She is a Ward 5 resident. Proposed Resolution 25-966, the Washington Convention and Sports Authority Board of Directors, Monica Ray Confirmation Resolution of 2024, was introduced on September 17th, 2024 by Chairman Mendelson at the request of the mayor and referred to the Committee on Business and Economic Development on October 1st, 2024. The committee held a public roundtable on the proposed resolution on October 2nd, 2024. If approved, this resolution would confirm the appointment of Monica Ray as a member with experience regarding economic development for the board. About another minute, Mr. Chairman.
Without objection.
For a term to end May 16th, 2028. Ms. Ray's career is focused on economic development of Congress Heights in Ward 8. She is a former president and executive director of the Congress Heights Community Training and Development Center. She's the chair of the Congress Heights Main Street, vice chair of the Anacostia Coordinating Council, and a leader with the Congress Heights Community Association. She brings a much-needed community-focused perspective representing Ward 8, where she works and resides, for the Events DC Board, which oversees the entertainment and sports arena in Congress Heights. Ms. Ray received a Bachelor of Science in Business Administration from Fayetteville State University. That, I move all three of the resolutions and ask to be placed on the consent agenda for today's legislative meeting.
Thank you, Councilmember. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
Madam Budget Director, no fiscal impact statement is necessary because these are nominations.
Correct.
Without objection, these measures will be placed on the consent agenda for today's additional legislative meeting. The next four measures were reported out of the Committee on Housing, chaired by Councilmember Robert White. In order for us to consider them, there needs to be a waiver of the Committee of the Whole Rule 403B, which is the rule that would have or requires that these reports be filed last Wednesday, and they were filed Thursday morning, which was timely for waiver of the rule. Let me state what they are. It's the confirmation of Toya Carmichael for the Housing Commission, Rental Housing Commission, and Erica Black and Edward Downs. It's confirmation for the Real Estate Commission and LRSP Program Eligibility Amendment Act bill. So I'll recognize Councilmember White to waive, if there's no objection, to waive Rule 403B in block for these four measures.
Thank you, Chairman.
To waive, a motion to waive the rule?
So moved.
And a motion to waive the rule. If there's no objection, the motion will be approved. Hearing no objection, the measures are before us. We'll begin with the Rental Housing Commission. PR 25-822, Rental Housing Commission, Toya Carmichael, Confirmation Resolution of 2024. Councilmember White.
Thank you, Chairman. The Rental Housing Commission serves as an independent appellate body for certain landlord-tenant cases and is comprised of two-member administrative judges and one chairperson. This measure would reappoint Toya Carmichael as an administrative judge on the Rental Housing Commission for a term to end on July 18th, 2027. Without council action, the resolution for her appointment would be deemed disapproved on November 10th, 2024. Judge Carmichael possesses the expertise, experience, and dedication to public service needed to excel on the Rental Housing Commission. Throughout her career, she has drafted judicial opinions, facilitated mediations, and provided guidance on legal and ethical issues. In her first year and a half on the commission, Judge Carmichael contributed to the commission's goal of resolving cases more efficiently by issuing 12 orders and at least one decision. Her collaboration with other agencies, such as the Commission on Human Rights and the Department of Housing and Community Development, highlights her commitment to improving government operations. She has expressed her dedication to delivering clear, legally sound, and compassionate decisions, which will benefit residents in front of the commission. Judge Carmichael's service has been recognized by awards from national and local organizations, including the National Bar Association, the Washington Bar Association, and the Georgetown University Law Center. Based on her qualifications and her statements during the roundtable, I'm happy to support her reappointment today and ask that they be considered on the consent agenda for today's legislative meeting.
Thank you, Councilmember. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, no fiscal impact statement is necessary because it's a nomination.
Correct.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. There's no objection. The next two measures to the Real Estate Commission will be considered in block. PR 25-914, Real Estate Commission, Erica Black, Confirmation Resolution of 2024. And PR 25-915, Real Estate Commission, Edward Downs, Confirmation Resolution of 2024. Councilmember White.
Thank you, Chairman. These resolutions would confirm the mayor's reappointment of two current members of the Real Estate Commission, which governs various professions in the real estate industry. It consists of 9 people, 3 licensed brokers, 2 licensed salespeople, 2 licensed property managers, 1 attorney, and 1 consumer member. Erica Black holds one of the salesperson seats on the REC. She is an experienced residential and commercial real estate salesperson and a former commissioner of Advisory Neighborhood Commission 7D. Her work has won her several industry accolades. Edward Downs is one of the broker appointees on the REC. He is a second-generation Washingtonian and is active in trade groups that work to support and develop real estate professionals. I appreciate hearing from both nominees at a recent roundtable about how they plan to continue their work on the REC, and I recommend that we confirm their reappointments. I move proposed resolution 25-914, the Real Estate Commission Erica Black Confirmation Resolution of 2024, and proposed resolution 25-915, the Real Estate Commission Edward Downs Confirmation Resolution of 2024. Thank you.
Thank you, Councilmember White. Are there questions from members? Madam General Counsel, are these two measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
And Budget Director, these are nominations, and so therefore no fiscal impact statements required.
Correct.
Without objection, these measures will be placed on the consent agenda for today's additional legislative meeting. Bill 25-49, Local Rent Supplement Program Eligibility Amendment Act of 2024. Councilmember White.
Thank you, Chairman. This bill is about our locally funded voucher program, the Local Rent Supplement Program. LRSP is closely modeled on the Federal Housing Choice Voucher Program. The DC Housing Authority, or DCHA, administers both programs. But you introduced this legislation, Chairman, to make sure that certain exclusionary rules from the federal program don't carry over into LRSP and get in the way of running a safe and supportive human services system. The print that the Committee on Housing marked up last week also contains a few tweaks relative to your original version we've had in effect on an emergency and temporary basis for the last couple years. We've tried to be responsive to concerns that DC Housing Authority and residents raised at our hearing, and while still keeping the local voucher program open to people who need it. Many local vouchers are used to help DC residents find a way out of homelessness. Federal voucher applicants typically have to produce various documents to prove their eligibility. But in practice, our caseworkers were finding that some residents, especially homeless residents, had misplaced important papers, and it would take many months of focused work to get replacements together. Your bill responded to this problem by allowing applicants to self-certify anything that they can't easily document. In the committee print, we created more opportunities for DCHA to perform their own records checks on things like income and employment to clarify that the agency isn't required to rely on inaccurate or inconsistent self-certifications. We also accepted DCHA's suggestion from their hearing testimony to allow them to require ID at the recertification stage, which is typically 2 years in. The print contains some safeguards to try and connect people exiting homelessness with assistance so that they can get IDs in time to comply. In addition, Chairman, your bill makes sure that a person's criminal history doesn't prevent them from getting a local voucher like it might if they were to apply for a federal voucher. We know for a fact that many of our community members returning from incarceration struggle to find housing. That's bad for them, and it might be bad for all of us if it makes it even harder for them to avoid reoffending. So this bill makes sure criminal history isn't a barrier to local vouchers at the initial eligibility stage. Now, once someone has a voucher and goes to apply for a specific apartment, the landlord may still be able to turn them away. The Fair Criminal Record Screening for Housing Amendment Act of 2016 set up rules for landlords to run background checks and rescind unit offers based on a long list of offenses that might show up in someone's record from the past 7 years. Today's legislation doesn't change that. It just makes a subsidy available whenever the person finds an apartment. In the committee print, we also created a narrow pathway for DCHA to revoke someone's voucher if they are actively creating a safety threat for other residents. May I have an additional minute, Chairman?
Without objection.
While already in the program. This responds to feedback from hearing witnesses and government officials who say that sometimes there is no meaningful way to respond quickly to clear, dangerous conflict between residents. Allowing voucher terminations is not something I take lightly because it may just increase a person's desperation rather than getting them to engage more safely and respectfully with their community. However, in my view, this is the right compromise to preserve the overall integrity and legitimacy of the local voucher program. It is my hope that DCHA will rarely take the extreme step of actually revoking someone's local voucher for unsafe criminal activity, and the print would bar them from doing so based solely on the fact of an arrest. Finally, I'll just make one note. While we work to address their concerns, DCHA staff have let my team know that they still have some questions regarding a few of the new safeguards in the committee print. The mayor has shared some of those questions, and we're working to determine whether a second reading amendment to address those comments is necessary. And if any member wants to get in on the conversation, please just let me know. Finally, I will say I received, like colleagues, the mayor's letter this morning. It talks about protecting public housing residents, which is confusing because this bill is about housing vouchers. And so I'm not sure if this is a fundamental misunderstanding of what this bill does, or if it's politics, whatever it is. It wasn't particularly helpful, but we've been reaching out for months to the mayor's office to work on this bill with us and have not received input from them. So we proceeded. But I did want to address that concern in case it did raise concern from any members. Thank you, Chairman.
Thank you. Are there questions from members?
Mr. Chairman.
Councilmember Henderson.
Thank you, Mr. Chairman. Councilmember White, I do have a couple of questions. I'm not on your committee, so I didn't have an opportunity to ask these during the markup there. I did want to ask about some of the changes that you all made in the committee print as it pertains to criminal activity that is occurring while someone is participating in the program. You know, in terms of my reading, you state that the authority would need a preponderance of evidence, but they cannot use a criminal arrest as part of that evidence. So, you know, we've heard from landlords where there have been situations where someone has conducted criminal activity on the property. That person may have been arrested, they have gone to court, and then a judge releases them to return to the property where the criminal activity and or violence has taken place. What are the options then for the landlord under this if the criminal arrests cannot be used against the tenant?
Great question, Councilmember Henderson, and I appreciate it. Arrests can be used. It just can't be the only thing used. So let's say the security cameras catch an assault and the person is arrested. There would seem to be enough evidence, but arrest by itself is not a conviction. And so we want to make sure it's not just an arrest. We don't want to see people put out because they were arrested. It has to be more than that.
Okay. The second question that I have is with regards to the self-certification. You know, 2 weeks ago, we took up legislation to change the self-certification rules for the emergency rental assistance program. I'm curious, are we not seeing, or do you not have similar concerns about this program also having self-attestation as part of it?
So the things that we allow residents to self-attest to here, we determine with the assistance of the folks who work with our homeless population. So emergency rental assistance, or ERAP, is one population. Many of folks with vouchers are coming out of homelessness or incarceration. And what we heard from workers who work with this population is that often they don't have IDs initially, and because of unique circumstances of homelessness, it can often take them months to get all of the documentation they need to get IDs. So they will have to show an ID when they recertify, but we don't want people to continue to live on the street for many months as they gather the documents that they need for something like an ID.
Thank you.
Councilmember Pinto wishes to be recognized, Mr. Chairman.
Councilmember Pinto.
Thank you, Mr. Chairman. And thank you, Councilmember White, for you and your team's continuous work on this important issue. As the chair of the Judiciary Committee, I hear from two constituencies that relate to this issue often. One is around returning citizens and making sure that we are providing opportunities for housing and employment and helping people get set up for success. And another is around people, whether they're residents of buildings or landlords, who have seen or been exposed to or victimized by a small number of people who are committing and have committed violent offenses either on the property or close by, and that becomes very harmful to the environment at the property. Typically, a landlord can use the eviction process to remove a tenant who commits a crime on the premises, but we've seen many instances where There's a lengthy eviction timeline. In some cases, residents have told me that their landlord hasn't even proceeded or taken any action to try to protect them from a harmful tenant who's been in their building. And my understanding is this bill is working to strike that balance by protecting residents and allowing DCHA to take adverse action, including the termination of an LRSP eligibility if a tenant commits certain dangerous crimes while participating in the program and poses a threat to other tenants, which I think is a really important safeguard to protect district residents, but that we're also maintaining the protections for our returning citizens to ensure that they have access to our local housing and voucher program and aren't automatically deemed ineligible, which is a really important need for our returning citizens. Can you just talk about the distinction between somebody who does have a criminal history in the past and seeking a voucher now versus somebody who is in the program and utilizing a voucher and then proceeds to commit a violent offense either on the premises or outside it, and how the committee struck that distinction?
Thank you for this question, Councilmember Pinto. So this bill does not limit in any way a landlord's ability to deny a housing applicant. So landlords can deny it. We just don't deny it at the point of a voucher. So we don't say, well, if you have a criminal history, you can't have a voucher. But landlords still have the same power that they would have with someone, paying, cash or check for their lease. So it doesn't impact people with criminal histories in any way different than, other applicants for a unit. With respect to people who engage in dangerous behavior in their housing, this is something I hear from residents about pretty often. There are a lot of folks who are concerned about things that they've seen or experienced. That we wanted to make sure that we struck a balance and did allow if people are posing a danger to themselves or other tenants, that their voucher can be revoked. The landlord will still likely have to go through the eviction process, but that's outside of the scope of this bill.
Thank you very much.
Are there any further questions? I have three. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
And Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does. And there is no fiscal impact to this legislation.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting.
Mr. Chairman, I'd like to ask that it be placed on the non-consent agenda.
All right. That is going to conclude our business. Looking at the agenda, it says next legislative meeting Tuesday, November 12th, 2024. We will probably have an additional legislative meeting on Tuesday, October 29th, which is 2 weeks from today, and is also 2 weeks before November 12th. The time right now is, but notice of if that is to happen, notice will be circulated by the secretary. The time is 12:53 p.m. and this meeting is adjourned. Call to order this meeting, an additional meeting of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council, and today is Tuesday, October 15, 2024. The time is 12:57 in the afternoon, and we're meeting in room 412 of the Johnny Wilson Building because there were some power issues earlier, and this room was better able to handle the technology so that the public can watch this meeting on Council Channel 13 or on the council's website, www.dccouncil.gov. This is the 31st legislative meeting of Council Period 25. We always begin our legislative meetings with a moment of silence. If everyone in the chamber and on the dais could respect a moment of silence. Madam Secretary, would you please call the roll?
Councilmember Allen,
Here.
Councilmember Bonds. Here. Councilmember Freeman,
Present.
Councilmember Gray, Councilmember Henderson.
Here.
Councilmember Lewis George,
Here.
Councilmember McDuffie,
Here.
Chairman Mendelson,
Present.
Councilmember Nadeau,
Here.
Councilmember Parker,
Here.
Councilmember Pinto,
Present.
Councilmember Robert White,
Present.
Councilmember Trahan White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. We have the consent agenda before us. There's one measure that was removed at the Committee of the Whole on page 2, item C1. That's Bill 25-49, Local Rent Supplement Program Eligibility Amendment Act of 2024. That's removed from the consent agenda. Are there any other changes to the consent agenda, which is pages 1, 2, and 3? Hearing none. We have the consent agenda as amended before us. All those in favor say aye.
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 Are there any opposed? The ayes have it unanimously. We'll turn to Bill 25-49, Local Rent Supplement Program Eligibility Amendment Act of 2024. Councilmember Robert White.
Thank you, Chairman. We discussed this legislation in the Committee of the Whole earlier today. This bill puts in a permanent law protections to allow more people to access local vouchers without their criminal background, immigration status, or ability to pull important documents together quickly, posing a barrier. It reflects relatively minor changes from the existing emergency law based on issues and concerns that have been raised over the last couple of years about the implementation of the voucher program. This legislation is necessary because we know from experience that some district residents, including people experiencing homelessness, were having a very hard time getting the housing assistance they needed when the DC Housing Authority applied all of the same rules that HUD requires for the federal voucher program. I hope my colleagues will vote in favor of this bill. Thank you, Chairman.
Thank you, Councilmember. Further discussion?
Chairman Mendelson.
Councilmember Freeman.
Thank you very much. Chairman Mendelson, I will not be voting in support of this bill. I think these programs are incredibly important. We absolutely have to find housing for all of our residents. The challenge that I have is the way in which these programs have operated has not struck the kind of balance that has been talked about in terms of creating opportunities for housing and also protecting residents in the housing where folks find a home. And I see this issue up and down Connecticut Avenue in particular, but in buildings along Ward 3, where we have folks who feel and are unsafe because of the behavior of residents in the building. We have situations where there's drug activity that's going on, prostitution activity that's going on. It's a serious issue. When you get to the place where the landlord identifies the issue and moves to change it, it is very, very difficult to change it. And in the meantime, folks are living in circumstances that they shouldn't have to live with. There's also the challenge in this program overall of really delivering services to the people who need the services. We don't know the payment status of the families involved in recent episodes in 2 apartment buildings on Connecticut Avenue, but we know that almost half the residents in those buildings are benefiting from the voucher program. And we had a 1-year-old who was killed, and we had a 5-year-old who was killed inside of 10 days. We are not delivering the kinds of services we need for people to succeed in this program. That doesn't apply to everybody. The vast majority of the folks involved are doing well and thriving, and it's fabulous that we've helped them. There's another group of people who, with more help, could succeed, and there's a group that needs way more than what we're providing. So I am very reluctant to lower barriers to entry in when we have not mastered how we operate the program once people are in, and how we deal with situations where folks need to be moved in order for others to be safe. So I will be voting against this.
I thank you, Councilmember Robert White. Actually, before you answer, let me turn to Councilmember Bonds.
Thank you very much, Chairman. I have a question about the process that I thought I understood from our earlier meeting. You mentioned that this was a process where an individual could be arrested, but in being arrested, charged with an offense, that would not be the only stipulation by which they would no longer be allowed to be on the voucher?
Not quite, Councilmember Bonds. I appreciate you asking for clarity. What the bill suggests is that arrest by itself is not enough to take away someone's voucher for criminal conduct.
All right, is it enough to have that individual moved from that particular location?
Just because they got arrested and nothing else? No.
What would be the other circumstances that would cause an individual to move?
I guess plenty of others. I don't want to start to try to define all of them because people may see it as.
Just give me a few, yeah.
So let's say, looking at the conduct that led to the arrest, for instance. So if you find out that I got arrested, that is not enough. But let's say you understand that I got arrested because I assaulted someone, that would likely be enough.
Okay, so if the assault, let's use that as an example. If the assault happened at the location where you're living, would that be grounds for having that person's voucher to be moved or have that person moved?
Yes, an assault would be enough. But just because you hear that I got arrested and have no other knowledge, that by itself wouldn't be enough.
All right, and so you're speaking, when you say just when you hear, are you speaking of the public, those who live on the premises, the same development, or are you speaking of the management office? I'm just trying to understand how this would really work. We frequently put in place measures that we don't all see the same process. And I'm just trying to understand what your thinking is.
So what the language of the bill is very narrow. All it says is that a arrest by itself is not enough to take away someone's voucher for criminal activity, because arrest by itself is not a conviction, it's not evidence, but all it says is that arrest by itself is not enough.
Let me read the language. I'm looking at the conformed print. The authority may inquire about or consider criminal background information for purposes of continued participation in the rent supplement program if the authority establishes through a preponderance of evidence that a person has engaged in criminal activity while participating in the rent supplement program, and that the person's continued participation in the rent supplement program would threaten the safety and well-being of other residents. The authority shall not terminate a person's participation in the rent supplement program based solely on a criminal arrest. I mean, the way I read that is that factoring in whether there is some risk or danger or threat of safety to the other residents, the authority absolutely has the ability to then consider termination.
That was my interpretation, but from earlier meeting, I didn't get that, and I was trying to understand whether it was an arrest that may have happened over a period of time or prior to being located, the individual being located on that premises, so. Thank you.
Further on the, Councilmember White, did you want to say more?
Yes, and thank you, Chairman. I just want to note, there's, I think, no daylight between, I appreciate Councilmember Fruman raising the concerns he raised, and there's no daylight between us on these. Loss of life is serious, and I don't think any of us take it lightly. There are also things happening with too much frequency that residents are concerned about and complaining about and angry about. And what I know, and I think what Councilmember Fruman is highlighting, is that there is no substitute for people getting the help they need. Because people are not getting the help that they need from our government, along with their vouchers, help that they are supposed to get. Many residents are getting angry about it, including residents with vouchers are getting angry, including members of this council getting angry that people are not getting the services that they need. You can't just take someone out of homelessness, put them in an apartment, not give them services, and expect them to succeed. That's not fair to them. It's not fair to their neighbors, and it's not fair to the program. So one, we have to keep demanding that our government give people the services that frankly we pay for, especially around PSH vouchers. Second, we have to keep pushing back as a council against cuts to human services. And third, what this bill does is creates, it's not all that we need to do, but it does create a safety valve for the public safety concerns that we've heard, which we try to address in this bill, which is different than how the emergency has been. So we're trying to take these issues into account, but there is no substitute for our government providing wraparound services to people. And I think until that happens more fully, we're going to continue to see things in communities that we don't want to see, and we're going to continue to hear frustration from the community and frankly from members of the council. Thank you, Chairman.
Thank you. Councilmember Henderson.
Thank you, Mr. Chairman. I wanted to ask a clarifying question, which I think maybe members of the public might have a similar question. So, Mr. Chairman, you read a portion of the bill that was related to, if someone is a threat to the community, et cetera. But just to be clear, this bill only deals with whether or not you can continue with the local rent supplement program. There's still a different process if a landlord then wanted to move towards eviction. Or when you lose your voucher, are you evicted? I don't think that's the case.
Are you asking me or Councilmember Robert White?
Either one.
Well,
This
my
is
answers are two different processes, two
Uh,
different decisions, two
yeah.
different decision makers.
I would agree with Chairman. These are two that we don't touch the eviction process here. When you lose your voucher and you are no longer able to pay rent, it is just like if you lost your job and you're no longer able to pay rent. So some people will move out and some will force the landlord to go through the eviction process, but that's
Okay.
not something we touch in this.
So then I guess I'm saying that to suggest that perhaps some of the issues that we're seeing with some of the concerns that Councilmember Fruman raised and that we're seeing from some of the landlords or building owners is not specifically around eligibility for a voucher, but when there is a particular incident that occurs on a property, how swiftly can they act? How swiftly does the law allow for them to act to protect the rest of the community? Thank you.
Thank you. Councilmember Tran White.
Yes, I guess just need clarity on when we talk about the convictions or arrests on the property, is there anything specific on what those arrests or convictions are? I heard Councilmember Fruman speak to the 2 deaths of the 1-year-old and 5-year-old in Connecticut Avenue. And from what I saw, I guess the 1-year-old was pronounced deceased from blunt force trauma, and the 5-year-old from someone was charged with felony child abuse. And I don't know if we even drill down to even consider what the charges or convictions are when we talk about how we use this legislation to give landlords authority or not authority to evict or move people along. If Councilman Rod White can speak to that as relates to just the wide range of things that can happen on a property.
Thank you, Councilmember White. Let me know if I'm not answering your question fully. This legislation gives landlords authority it gives the city authority to withdraw someone's voucher if they are a serious health or safety risk to their fellow tenants. The only limitation is that arrest by itself is not enough is not enough evidence to withdraw someone's voucher.
That gives me a clear understanding. I have more questions, but I'll digress there.
If I could add to that, so if a person was arrested for, what do I say, nonviolent civil offense, there's such a thing, let's say a property offense in another city. I'm trying to think of something that just has no
So
relevance to the.
I've seen that incident where this is in public housing, particularly where they have a policy where you can't smoke cigarettes on the property, which is they catch you smoking, it's a crime. But there's been a lot of back and forth between residents, and this is not that, but that's a issue where there's a crime or something that's prohibited on the property that elevates to a crime, or breaking up a rule that pretty much gave people the opportunity to get you off the property they wanted to. And then mind you, in a lot of these instances, it may be someone who's living in that property. Most times an older person on the lease and a grandchild or some other person. Now the whole family is in jeopardy of being evicted because this person was doing something on the property, sometimes egregious or sometimes violent, sometimes just a lot of times smoking weed or smoking cigarettes on the property.
So I read the language, and there has to be I would say there has to be a correlation with a threat to other residents on the property, a threat to other residents or to the property itself. So I'm trying to think, if somebody, let's say, got arrested for mortgage fraud. I'm not quite sure what relevance that has to the safety of other residents, so the mere fact of being arrested would not be sufficient. Unless somehow it could be shown that that's a threat to other residents. Did you have other questions? So I'm going to speak for a minute because I'm very concerned about the mayor's position with regard to this legislation. And members may recall that she vetoed the legislation earlier this year. I think it was in April, and we overrode the veto, I think with an overwhelming vote. And I spoke then. And part of my concern here is that I think that the mayor, through her rhetoric, stokes the fears of residents such as in Ward 3 and along Connecticut Avenue. And I think that that's very unfair, and it is actually inappropriate. So I kind of want to speak to that. This legislation had a hearing in June of 2023. As I recall from the record, the mayor declined to testify on the legislation. However, the Housing Authority did testify. And my understanding, and this is going to be a question, Councilmember White, is that the Housing Authority ultimately did submit some technical comments. And did you make changes to the bill based on the Housing Authority's suggestions?
Yes, Chairman, they testified, they raised some comments. We made changes to the bill based on those comments, the Housing Authority.
So to the extent that the mayor is claiming that the Housing Authority is somehow harmed by all this, my recollection is that just was not their testimony at the hearing in June of a year ago. And since then, they've made comments and you've accommodated their comments.
correct?
I want to add as well that, and this point has been made, but I want to make it again. This is about applying for a voucher. This is not about applying for an apartment. It's a separate decision made by a separate decision maker. And so the concern that folks have with regard to that somehow we're making it more possible that undesirables, whatever that means, could suddenly be appearing in apartment buildings, that's a separate decision from what's in this legislation. I would add as well that this legislation, I think, clarifies that the Housing Authority has the ability to use its levers, such as withdrawing, revoking a voucher privilege if the person is deemed to be a threat to the property. So that's actually a strengthening with regard to public safety. I also want to make clear that we debated the issue of self-certification with regard to the Emergency Rental Assistance Program a couple of weeks ago. Folks who have emergency rental assistance or applying for emergency rental assistance have to, by definition, have an apartment. They're not homeless. However, with regard to folks who are applying for a voucher, they are overwhelmingly homeless. For instance, a survey of homeless people in Noma found that 68% did not possess an ID. Likewise, undocumented immigrants, of which are estimated 21,000 in the district, often lack any identity documents. And for folks who have been out of state, it takes a very, very, very long time. If they're in state, it takes a long time to be able to get identity documents. So this is about applying, and especially for folks who are homeless, making it easier for them to get a voucher. I just wanted to put that on the record as well. Seems like I've provoked more conversations. Councilmember Fruman.
Thank you very much, Chairman Mendelson. I think much of what this legislation is trying to do is positive, but the idea that what's going on is the mayor's rhetoric is stoking fear on Connecticut Avenue is not right. I mean, the people who are feeling threatened are feeling threatened. They didn't get a call from the mayor, and they're not making it up. This is serious what's going on. The police calls to these buildings are enormous, the amount of resources that are devoted to it. So I don't think that anybody here, I think what's good about this conversation, I'm sure that this legislation will pass, but if we begin to have a real conversation about how this is working and not working, that's important, but it's not that the mayor's rhetoric is stoking something. This is a challenging situation. We need to put our heads together to figure out how to solve it. One of the things that you talk about and others have talked about is it can be up to the landlord to deal with the situation. Well, part of the challenge we have here is DCHA has rules that come from the federal rules about who can qualify and who can't for housing, for in public housing, and that's to protect the other people in public housing. Well, then it goes over to the private landlords, and it's not operating in that way. And we have an incentive system where folks can get paid, particularly in rent stabilized buildings, way more for a unit if it's through a voucher program. And that creates an incentive for the landlords to look the other way on these kinds of issues. That's been a giant challenge. It's also another challenge that they all feel stretched financially. So you have one security guard who roams 4 buildings up and down Connecticut Avenue. That's not going to help protect people. We need to fix this landscape. And that's why I don't want to be taking this step. I want to be taking other steps to try to address the real issues.
If there's no further discussion, we'll have a vote on the bill.
Mr. Chairman.
Councilmember Pinto, second
Thank
round.
you. I have a question, and this might be better suited for Councilmember Fruman or Councilmember White. But in the examples that you're talking about on Connecticut Avenue, where there have been certainly extremely troublesome reports and sometimes violent reports of crime happening on the site, the language that this bill talks about with that being allowable for a landlord to take eviction steps if something like that happens do you think that that language is sufficient to address that concern that you're talking about? Or is there another mechanism that you'd like to see in this bill or another bill that better deals with those instances where violence is occurring?
Thank you, Councilmember Pinto. This bill has nothing to do with evictions at all. Doesn't change any eviction process, doesn't address any stipulations in a lease. So what we would need to do is probably move the courts faster on evictions. I think that from what I hear from landlords, that's generally the holdup. But this bill does not in any way limit, expand, address evictions. This is just about vouchers and whether or not people qualify for vouchers. But what we've added is the ability of the housing authority to withdraw vouchers for health and safety. And so, yes, we need to do more, but we heard the housing authority and residents loud and clear. We want to give some opportunity to withdraw vouchers. But again, the bill does not touch the eviction process at all.
Okay, so then maybe back to Councilmember Fruman, if I may, the availability to cut short or terminate a voucher in the event that violence has occurred, does that not address, not holistically, but does that not kind of move things in the right direction for what you're seeing and hearing from those properties most frequently?
Thank you, Councilmember Pinto. Yes, marginally this can help because you can have two different categories of landlords. You could have a landlord who is diligent about trying to make sure that the other residents are protected, and they may move in a situation like this for eviction. Nobody wants to be pro-eviction, but we have to have accountability here. And in situations where somebody is threatening somebody else, and I get emails every day from different people who are in this situation. Really, they're not kidding. And you can have a landlord who moves and tries to get it done, and in that setting, that's, in my opinion, a positive thing. You might have a landlord who does not, but if DCHA withdraws the voucher so that landlord is no longer getting paid, then maybe that would incentivize the landlord to do something. So yes, it's not that everything about this bill is bad. Some of the things about this bill are good. I just think we have bigger problems about how we deal with this that makes me not want to go in this direction at this moment.
I understand. Thank you so much for that clarification. Thank you, Mr. Chairman.
We seem to have provoked more debate. Councilmember Bonds?
Thank you, Chairman. I just wanted to join in this part of the conversation because if you recall, or some of us will recall, during COVID, we did put in place emergency and temporary that spoke to the eviction process when it was needed because of situations that may happen on the premises. So I will talk to Councilmember Fruman about that, and perhaps we need to look at that to begin to address the situation that he was speaking of. And for those who may remember during a few years back, during many of the housing meetings that we held here at the council, there was discussion from tenants and from landlords about the concerns for safety on the properties. So this is not anything new. That was why I was asking originally the question about how would this work, your bill in particular, the one that we're to discuss today. So thank you.
Thank you, Councilmember. If there's no further discussion, we have the bill before us. This is first reading on Bill 25-49. All those in favor say aye.
Aye.
Mr. Chairman, please, oh, no.
Everybody's recorded as a yes, except for Councilmember Fruman, who is recorded as no. So the measure is approved on first reading. Turning to the non-consent agenda on page 4, the first measure, yes, is final reading on Bill 25-985, Hotel Enhanced Cleaning and Notice of Service Disruption Temporary Amendment Act of 2024. Councilmember Bonds?
Thank you, Chairman. Today, I'm urging my colleagues to support the Hotel Enhanced Cleaning and Notice of Service Disruption Temporary Amendment Act of 2024. On October 1, 2024, the council passed the Emergency Amendment Act. The temporary version of the bill that we're discussing today also passed first reading on October 1. The legislation authorizes the mayor to issue regulations that establish requirements for cleaning and maintaining DC's hotels and motels, and to establish standards for public notice of lodging establishment service disruptions. As we sit here today, the tourism industry continues to rebound, as evidenced by recent data trends. This industry, which has generated up to an average of $7.1 billion annually in pre-pandemic years, including around $2 billion in spending on hotel rooms alone, has skyrocketed in the last 2 years. And therefore, our sisters and brothers continue to enjoy wages and work schedules. What we don't know, however, is this industry stabilized? And for this reason, the unions and the hotel industry continue to meet. Hopefully, they will reach a permanent solution soon. And this solution would enable the mayor to issue regulations of hotel cleaning requirements as today's temporary legislation provides. In DC, our tourism industry has spent $10 billion during their travels here. This is up from $8.1 billion in 2022. And this tourism helps to support 100,000 plus jobs in DC. These are records. And so, Mr. Chairman, I'm presenting this temporary legislation again in hopes that the industry and the union will see a resolution so that we can move forward with the mayor generating the necessary regulations. I move the bill today.
Thank you, Councilmember. Councilmember Tran White?
Yes, I know that we started this conversation during the pandemic and coming out of the pandemic to ensure that our hotel and restaurant industry can continue to grow. And this legislation addresses the cleaning issues that may be issued by the mayor, also to address the service disruption. What I don't know from this legislation is, if you can help me, Councilman Bonds, is what has came out of the conversations between the hotels and unions, if any, to kind of land this plane, because we're continuing down this road, but I don't know what has been the result of those conversations, if you know at all.
Well, as you can expect, the unions are very interested in continuing the plans and the systems that they have in place and have had in place during the pandemic. The hotel industry is a little guarded in that they're not sure that the industry has really stabilized. They see their business more seasonal. And so they have not yet come to a resolution, but they are talking to each other. And I think that's important because, as you know, the hotel industry across the country is seeing some situations where their unions are up in arms, and there are situations where there are strikes in place, and we do not want that in the District of Columbia. And so I think having them to continue the discussion on a, through a temporary basis is the way that sort of settles things for us until they reach some solution, and a temporary piece of legislation will just give us another few months.
Thank you, Councilmember. Councilmember Lewis George.
Thank you, Chairman. Councilman Bonds, I wanted to know, have there been any, since our last meeting, have there been any progress between labor and hotels executive within the last few weeks? And then, I guess, I just think we either need to introduce a permanent and have a hearing, or either have a roundtable on it. I just, as we have to do something to prompt them to put fire under them to have conversations at this point. So I'm wondering if that's a strategy that the Labor Committee has considered, like actually introducing a permanent and having a hearing, or separately having a roundtable, so that we can sort of move the ball and sort of force these conversations to actually occur. And then to see what updates we have since the last meeting.
Thank you very much for that comment. The truth of the matter is that both parties are comfortable still talking to each other. This legislation does not give us the authority to really set whatever the standards or the regulations are. That would be done through the mayor's, through the executive side of our government. And we can have a hearing on just that. If you're talking about the language that is currently before us, it would just simply give say, well, the mayor shall or the mayor will, in fact, do a series of regulations, but it would not stipulate what the regulations would be. We would need a different format, and I'm not sure that we have that authority. This is a union matter outside of the district government unions. This is, private sector.
Thank you, Councilmember. If there's no further discussion, Councilmember Fruin.
Thank you very much, Chairman Mendelson. My sense of the landscape here is a little more pessimistic in a way. I mean, I support this, and I had for a time thought, well, we need to buy time for the union and the industry to sort out the negotiations, and then we can get out of this business. But my impression is that between the union and the association, there are multiple issues, and this is one, and they need to resolve all of them together. When they resolve them all together, assuming that they agree to this kind of daily cleaning regime, we still will be in a situation where non-unionized hotels, would the unionized hotels be at a disadvantage relative to the non-unionized hotels because they have a higher obligation? And it could then mean we still need to do regulations in this area. So I wish we weren't in a place where we were legislating or the mayor was regulating in this area, but I have a feeling when the plane lands, we will be. And that the plane will land when the parties resolve 2 or 3 issues in front of them, not necessarily just this one.
Thank you. If there's no further discussion, the vote will be on Bill 25-985, final reading. All those in favor of the bill say aye. Aye.
Mr.
Opposed?
Chairman, please record me as voting no.
The ayes have it. Councilmember Pinto will be recorded as voting no. We'll turn to emergency bills. The first is the declaration is PR 25-1021, Cherry Blossom Festival Grant Emergency Declaration Resolution of 2024. So moved. The declaration enables us to consider the bill, which is to correct a typographical error in the fiscal year 2025 Budget Support Act. The council added $500,000 to the mayor's proposed budget of $1 million for a matching grant of $1.5 million for the National Cherry Blossom Festival. The funds are loaded in the non-departmental account. The full amount of $1.5 million is included in Section 2112A of the Budget Support Act, but the reference to the total amount in Section 211B mistakenly states $1 million. Emergency legislation is necessary to correct this Budget Support Act, to correct the Budget Support Act to allow for the transfer of the unambiguous transfer of the full $1.5 million to Events DC. So as I said, so moved. Discussion? On the declaration, all those in favor say aye.
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 Opposed? The ayes have it unanimously. The underlying bill is Bill 25-1000. It's a little hard to believe that we're up in the 4 digits. So moved. Is there discussion? On the bill, all those in favor say aye.
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 Opposed? The ayes have it unanimously. The next measure is PR 25-994, Early Childhood Educator Pay Scales Emergency Declaration Resolution of 2024. So moved. This legislation would revise the current early childhood assistant and lead teacher compensation scales to the Early Childhood Equitable Educator Compensation Task Force recommended compensation scales. In the fiscal year 2025 Budget Support Act, the Early Childhood Educator Equitable Compensation Task Force was instructed to recommend changes to meet the FY25 budget and further limit fiscal pressures on the program through the financial plan and beyond. Folks will recall that we budgeted $70 million for this program. And this before us is consistent with that. On September 30th, the task force released a report, which is available on LIMS, that includes a proposal for a lead and assistant teacher compensation scale based on the FY25 budget appropriation. The proposed compensation scale establishes new minimum salaries based on credentials, balancing the limits of the Pay Equity Fund and the compensation and benefits of pre-K and kindergarten teachers employed at the District of Columbia Public Schools and District Public Charter Schools. The current compensation scale expires in December, and therefore it is timely to be moving this now. As I said, this is consistent with the budget that we have already adopted, and is also, this legislation reflects what the task force recommends. I already said so moved. We have the declaration before us. Is there discussion? Councilmember Robert White.
Thank you, Chairman. I want to thank the Early Childhood Educator Equitable Compensation Task Force for their work to develop recommendations for the Pay Equity Fund funding formula that balances budget constraints and the district's promise to increase pay for child care providers and expand access to high quality early learning. This is a particularly important and special issue to me because the Pay Equity Fund is born out of the Birth to Three for All DC bill that I wrote along with Councilmember Vince Gray. For folks who have not followed this for many years, when we had a hearing on the 2 original bills, there were people who testified for business, for education, for public safety, that investments in early childhood education were going to pay off significantly for our city, because this is when the majority of core brain development happens, and the education in the early years determine many outcomes much later in life. And so what we realized was, because of the importance and difficulty of the work, we could not have these educators making minimum wage and put them on parity with their colleagues teaching 4- and 5-year-olds in DC schools. Now, this does come with a price tag, even if it is good for the city. So inevitably, the cost of the Pay Equity Fund will rise. As pay increases, we expect to see growth in the profession, improved job retention, and more educators pursuing higher credentials as they are better compensated. These are positive impacts that we envisioned, and achieving high quality early childhood education for all DC children requires a robust and fairly compensated task force. We are setting the model for the nation right now, but it does come with a price tag that we have to be aware of and be committed to funding. I'm committed to working with my colleagues to continue our investments in the Pay Equity Fund and in our early learning system as a whole, and developing sustainable funding to ensure long-term stability and growth of this very important program. So I look forward to voting in favor, Mr. Chairman. Thank you.
Thank you. Councilmember Henderson, did you wish to speak?
Thank you, Mr. Chairman. Thank you for introducing this important legislation. I want to say at the offset that early childhood education is not babysitting. I think we agree with that, but perhaps representatives from Utah and South Carolina don't. So I'm going to say it again. Early childhood education is not babysitting. The years birth to 5 are some of the most critical development years. And prior to the establishment of the Pay Equity Fund, the individuals responsible for a great deal of the care and education for these children were paid the least. Many were making barely minimum wage. Many relied on other forms of assistance to survive and care for their own families. They were hearing about the great extracurricular activities that their students were participating in, but couldn't afford to pay for their own children to participate in these activities. They were putting off preventative care and healthcare needs because they lacked access to healthcare. And when you add the demographics of the individuals who primarily do these jobs, Black and brown women, the situation harkened back to a glossed up version of the 60s. These educators simply deserve more. I'm glad we were able to preserve the Pay Equity Fund earlier this year, as well as the Healthcare for Childcare program. I'm going to say this now. I know that the next budget cycle is going to be tough, but I feel like we have over 4,000 reasons to ensure that this program is not again left on the cutting room floor. When I said earlier this year that DC was the envy of the nation for this program, I meant it. Across the country, jurisdictions are having to consider this problem. How do we get qualified individuals to do this work, and how do we pay them fairly so they want to stay and grow in this profession? Childcare is a workforce issue. It is important to the economy. I want to take the opportunity to express my immense gratitude to the Early Educator Task Force chaired by Abigail Smith for their work. This has never been easy, trying to do something that has never been done in the early childhood space, especially outside of a union. But it was even more daunting to have to make changes to the program within the funding constraints. And so I want to publicly recognize them, as well as the team at OSSI, the Health Benefit Exchange Authority, and a late assist from the Office of Revenue Analysis at the CFO's office for their work and creativity to make sure that this program sustains. I look forward to continuing to work with my colleagues to ensure that this goes forward. No one wanted to see any minimum salaries decrease, but I want to state something that was included in the report, that this is a floor. It's not the ceiling. And so as other institutions, child care development facilities are able to find more funding to be able to support their workers, I hope that they do so because the work that they provide is so critical to our future residents and citizens, as well as education overall. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Trayon White.
Thank you, Chairman. I want to thank all my colleagues for the tremendous amount of work to get us thus far. As mentioned, this is a floor. I remember probably about 6 years ago, I was in a community conversation with Councilmember Vincent Gray. I believe maybe Grasso was there as well. Just seeing and hearing the hearts of those who provided education to our youth and young adults year round, mostly working between 8 and 10 hours a day, frustrated, trying to figure out how we were going to support them as they were mandated to go back to school to get an education and increase their credentials. I think it was very responsible of us to figure out how to pay them equitably. And this bill speaks just to that. The Early Childhood Educator Pay Equity Program is an essential step to ensuring fair compensation for our educators. Beginning in January 2025, I believe this will set precedents to increase the minimum salaries for teachers who create a critical role in inspiring and educating the powerful minds of our next generation. So we should not take this lightly. In Ward 8 and other communities, childcare workers are often women of color who deserve a living wage, and even higher than a living wage, as DC is probably one of the highest places to live per capita in the country. And we are addressing that historically through these inequities by increasing more money in parents and workers' pockets. Ensuring pay equity will allow us to attract and retain some of the best educators, ensuring consistency and high standards in the classroom. As mentioned, these are not babysitters. These are educators who are qualified to bring forth those gifts and talents in our babies to help them matriculate to be whatever they desire to be. This is not just an update about salaries, it's investment to our future, our children, and the economy as a whole for our future. I just want to say this, we heard from them and we want to honor them by paying them. We should keep that commitment to them because they have kept the commitment to us, especially during the pandemic, holding it down for us across the district residents who had to go to work, who had to figure it out. They came and supported and held the next generation down. So it's incumbent upon us to support them. And I think that the threshold of the actual bill was around 70 million in annual funding through FY 2028. We have to look at how we can do even more. I want to thank you and all those who supported this and the thousands of educators throughout the district who are working hard to ensure that we get equity in our education for our babies. Thank you.
Thank you, Councilmember Parker.
Thank you, Mr. Chairman. I am grateful to the Early Childhood Educator Equitable Compensation Task Force for their work to provide us with recommendations to adjust the Pay Equity Fund funding formula given our fiscal year 25 budget constraints. The task force was given the responsibility of making recommendations for how the Pay Equity Fund can operate with an almost 20% reduced budget after Mayor Bowser cut the program when she presented the council her fiscal year 25 budget. And the council fought to replace the program's funding, saving $70 million of the existing nearly $90 million program budget. The task force's work was no small feat, and the pain of these forced cuts will be felt across educators and early childhood facilities. I want to be unequivocal in my support for this program, bringing the salaries for thousands of early childhood workers, many of them women of color, up to a livable wage in exchange for them seeking higher education. Before the Pay Equity Fund, early childhood educators made up to roughly 33% less than their K-8 peers. What's more, we know that a child's early years are among the most critical, and investing in our early childhood educators is among the best investments we can make to provide more care, more learning, and more seats to those young people who need it most. I commit to working with colleagues and partners to ensure the Pay Equity Fund is sustainable in the long run, and by that meaning, we increase pay across the financial plan accounting for inflation, expand health coverage, fairly compensate veteran teachers, and protect the fund for years to come. While OSSI works to implement the recommendations of the task force, it is my fervent hope that Mayor Bowser will respect the will of this body and the essential work of early childhood educators by not cutting the program again. Thanks again to the Early Childhood Educator Equitable Compensation Task Force, our educators, and the many advocates who helped us get to this place. Thank you.
Thank you, Councilmember. Councilmember Pinto.
Thank you very much, Mr. Chairman, and thank you to you and your team and everybody on the council and the task force and OSSI who has worked so hard to promulgate these recommendations. And I want to say that there are pieces of this that we're codifying today, but we will continue working with OSSI and others to ensure that the recommendations of this important task force can be implemented. I wanted to address just kind of 3 points that I think childcare and early childhood education is so important for families, for educators, and for our economy more broadly. We know that our families depend on access to high quality early childhood education because every parent wants a safe and enriching early childhood education experience for their children. And we've seen research develop over the last several decades that has overwhelmingly shown us that access to high quality early education supports the foundation for your future, strong language skills, a foundation for other learning in science and math, which I know we all continue to be focused on, higher high school graduation rates, college enrollment rates, and lifetime earnings overall. Children with access to skilled and supportive early childhood educators are better able to manage stressors and reduce long-term impacts of these stressors with confidence that their kids are getting excellent care and instruction. We also know how important early childhood education is for our educators. To provide strong early childhood care education, we must ensure that our educators are trained and well paid. We cannot attract, maintain, and continue the skilled and effective early childhood workforce that our children need if we cannot offer sufficiently competitive salaries to those educators who are overwhelmingly Black and brown women. The Pay Equity Fund is an exemplary tool that we have developed in the district to support this workforce and to support the transformative work that they do to prepare our children for opportunity-rich futures. And lastly, the Pay Equity Fund is also important to our city's long-term economic recovery and growth. Building the district's middle class, growing our small businesses, and attracting new economic opportunities require that we have a skilled and qualified workforce. As we try to rebuild from the economic challenges of the pandemic and work to retain and attract new businesses, one of the most prevalent factors that I continue to hear about businesses' decision to locate in the district or not is the quality of our workforce. Our economic future depends on supporting the development of our young children today and ensuring that people can get back into the workforce and have opportunities for their children to get access to high quality education. So I really appreciate, again, all of the work that's gone into this, the Early Childhood Educator Equitable Compensation Task Force, for all of their work over the summer to put together these recommendations. And we will remain vigilant and committed as we head through the next couple of months into next year's budget to ensure that we can all be on the same page with how vital this program is to our families, to our educators, and to our economy in the district. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Allen.
Thank you, Mr. Chairman. I know a lot of us want to speak to this. I will attempt to be very brief because my colleagues are making a lot of great points. I come to this in two roles, both as a council member, very proud of helping create and fund efforts like this for our educators, and also as a parent. I think about my own kids and the individuals that help provide love, care, and education for them, which allowed both me and my wife to be able to get back to our work. But valuing their work was incredibly important. And so I think about those individuals a lot, and I've stayed in touch with several of them. Just the other week, ran into a lot of folks who helped educate my son in those first few years. And they resoundingly said, thank you to this council, every single one of us, for recognizing and valuing their work and the pay that they should be getting and for fighting for this. It's kind of breathtaking to think about where we are from last spring when the mayor attempted to eliminate the funding for this. I'm not a stranger to seeing coalitions be built and be able to mobilize quickly. This was one of the fastest and broadest coalitions I think the city has seen to push back on what would have been a devastating move for our city, for our economy, for jobs, for workforce, and really fight to make sure that the dollars were preserved. I want to echo my colleagues' comments with gratitude to the task force that really worked hard to put forward what we have in front of us. I don't pretend it was easy, but I appreciate the hard work that they've done. Because at the end of the day, and again, as we head into what may be a very tough budget again next spring, we've got to make sure that we live the values that we espouse, protect the very people that actually keep our economy moving. And that means we pay our educators fair and competitive wages. And I think this council is committed to doing that. I hope we see this be a commitment across branches of government so we don't have a repeat of last spring. But I think that our educators, our families, all across the city are counting on it. So I'm proud of what we've done today. Appreciate the hard work that the task force put in to help make a lot of these recommendations, and look forward to enthusiastically voting yes today and continuing the fight to protect this. Thank you, Mr. Chair.
Thank you, Councilmember Allen. Councilmember Lewis George.
Thank you, Chairman. Early childhood researchers say a child's first 3 years will shape their lives. And our district's early educators, parents alike, all agree to this. And the Pay Equity Fund has been a recognition of our investment in our young people and an investment in our future. Birth to 3 are critical years of social, emotional, and cognitive development that ready children for school and beyond. what they can accomplish and what they will accomplish by having high quality early childhood education is just phenomenal. And we will be able to reap the benefits just like we did as a district in pre-K3 and pre-K4 and leading the way. The district has been leading in early childhood education for decades, and we continue to do that work through the Pay Equity Fund as well. I am so grateful for the Early Educator Equitable Compensation Task Force for their hard work. I want to thank the Office of the State Superintendent of Education for their great work. I really want to thank the Birth to Three Coalition and all of its amazing partners for the work they do. And I want to thank our early childhood educators. Many of them, in addition to doing the work they do every day and investing in teaching our young people, also showed up to the Wilson Building, showed up in community groups. The one thing I loved about the task force is they centered the voices of early childhood educators. They actually brought early childhood educators to the table, listened to them, and got their feedback and their advice. And when you center the voices of those who are most impacted, you get a greater outcome. And I think we have seen that outcome, and we see that outcome in what we have before us today. So I look forward to continuing to work with my colleagues. I was proud through the Homes and Hearts Amendment to be able to create revenue and funding for us to be here today. And I'm proud to continue to work with my colleagues so that we can continue to make sure this effort continues and is funded. So thank you, Chairman. I look forward to enthusiastically voting yes today.
Thank you, Councilmember. Councilmember Nadeau.
Thank you, Chairman, and thanks to all my colleagues who have spoken before me. You know, one of the points that I just really want to drive home today is who and why this is important. We have been legislating wider access to early childhood education for years now, and we're going to have to continue doing it until it's fully implemented. When we passed the Birth to Three legislation authored by Council members Robert White and Councilmember Gray, we put out that blueprint for what we wanted our city to be like and what we wanted to offer, which is high quality, accessible early childhood education. The piece we're talking about today is the one that makes it all come together, because we can raise education standards and we can put out subsidies for facilities, and we can increase the number of subsidized slots. But if we're not adequately paying the workforce, there's not going to be teachers there to take care of these children. You've heard me talk about my girls. If Semillita's Early Learning Center could not pay their employees adequately, I wouldn't have been here on this dais because my babies wouldn't have had anywhere to go during the day. And then to know, until we passed the Pay Equity Fund, that they weren't even being adequately paid. The people that cared for my children, that kept them safe all day, 5 days a week, so that I could come to work and serve the people of Ward 1 in the District of Columbia. The fact that some of them were eligible for Medicaid, some of them working second jobs, that's not right. So we did this. And then the mayor decimated the Pay Equity Fund, and we had to do it again. So we're not in a situation today that we thought we would be in, which is further down the road and each year adding to this. Instead, we had to find a way to restore as much as we possibly could, and then ask a few people, some of the people in this program, to wait a little longer. That's not where we thought we would be. It's where we are. And I do want to emphasize that this council has been shoulder to shoulder on this issue. We need our mayor to be shoulder to shoulder with us, and shoulder to shoulder with those women, mostly Black and brown women who show up work every day to ensure that our workforce can go to work and to ensure that we can have the deep bench of early childhood educators that we need, and to retain the excellent ones so that our children come to school ready to learn when they are in pre-K3 and kindergarten, because we know this all goes together. Chairman, I want to thank the Early Childhood Educator Equitable Compensation Task Force for its work. we can't legislate everything in this bill today. And what that means is we are obligated through rigorous oversight to ensure that OSSI implements the recommendations that we're not legislating. And I know we'll stick together on that. I want to thank the Birth to Three Coalition, which has been fighting to keep this together since we first passed the law. Thank you, Chairman.
Thank you, Councilmember Nadeau. Councilmember Fruman.
Thank you very much, Chairman Mendelson. I'll join all my colleagues in expressing the deep gratitude for the work of early childhood educators. They're not just professionals, they end up being parts of families. I see it in the experience of my grandchildren and know how important the folks at the Early Childhood Center are for her and for her family in giving advice and helping and supporting. It's a critical function. It allows businesses to succeed, people to work, children to thrive. We really need to and have been valuing it. The step we're taking today is a very, very important one, implementing a piece of the puzzle, the biggest piece of the puzzle that the task force pursued. I join in thanking all of the different players, the task force, OSSI, the CFO's office, the advocates who pushed for this. This is really important and we need to stay on it and keep pushing it forward in ways that can grow the program and let it serve well as many people as possible. I also want to give a special thanks, Chairman Mendelson, to you, because in this process, we had to find the money to make this happen. And none of us individually could do that. And you found the path to get us to the place where the table was set and we could get this done. And that is critically important. So thank you for that. There's another area in this space, the pre-kindergarten enhancement and expansion program and PKEEP. And that's a very important piece of the early childhood education landscape. It was a piece that looked like it might fall between the cracks. And again, Chairman Mendelson, you found the money in order to keep that program going in the way that it has been going. It is another very important piece of the puzzle. I congratulate us on getting this all done and recognize that this is a part of the process. We need to keep strengthening all of these programs going forward. Thank you.
Thank you, Councilmember. So I do want to say one thing to correct the record, or to clarify the record, let's put it that way. Earlier, I was critical of the mayor, which he richly deserves with regard to the housing bill for criticizing it. But on this one, I want to remind folks of the facts here. The mayor did not want to zero out this fund. Now, it's true that she did want to cut it, but she did not want to zero it out. And members will remember, and the record should reflect, that the chief financial officer at the last minute insisted that in the budget she submitted, in order for him to say it was balanced, that she had to add something like $50 million to one of the reserve funds. And in the last minute, there were not a lot of options for her, so she picked this one. And I made it clear even before the budget was submitted that I was not going to agree with what the chief financial officer proposed. That is, that we would budget for restoring the reserve fund. And that was how we were able, since all of us agreed, that we were able to restore roughly I think it was $53 million to this fund, and then added to it to bring it up to $70 million. So the record should reflect that. And the mayor was clear at the time she presented the budget that it was a choice that she did not want to make. I believe everybody, or almost everybody, has spoken on this, so let's get to a vote on the declaration. The vote will be on PR 25-994. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. We have the underlying bill, Bill 25-992. So moved. Is there discussion? On the bill, all those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. If there's no objection, I'm going to move the two temporary bills, first reading on temporary bills together. They are Bill 25-1001, Cherry Blossom Festival Grant Temporary Amendment Act, and Bill 25-993, Early Childhood Educator Pay Scales Temporary Amendment Act. So moved. Is there discussion? I do want to say to reflect any changes to the emergencies, but actually there were none. If there's no discussion, the vote is on the two temporaries. All those in favor say aye.
Aye.
Are there any
Aye.
opposed? The ayes have it unanimously. That is going to conclude the business for this meeting. As I indicated at the end of the committee of the whole, there will probably be an additional legislative meeting on October 29th. That decision has not yet been made, but members should keep their calendar free. The time is 2:08 PM and this meeting is adjourned. Wow.